Mr. President, in the days since we lost our colleague and dear friend, Congressman John Lewis, many of us have come to the floor to talk about his extraordinary courage and tenacity. At the age of 25, he joined 600 civil rights activists to march across the Edmund Pettus Bridge in Selma, Alabama, in pursuit of the right to vote. We've talked about how that day became known as Bloody Sunday, after John and the other courageous marchers were met with brutal beatings from Alabama state troopers. And now in the days that followed, President Lyndon B. Johnson called on Congress to pass the Voting Rights Act. It was 55 years ago this week that President Johnson sat at a desk in the President's room, right off this chamber, a room we walk by many times each week, and signed the Voting Rights Act into law. He noted at the signing ceremony, and I quote, "Last March, with the outrage of Selma still fresh, I came down to this Capitol one evening and asked the Congress and the people for swift and for sweeping action to guarantee to every man and woman the right to vote. In less than 48 hours, LBJ said, I sent the Voting Rights Act of 1965 to Congress. In little more than 4 months, the Congress, with overwhelming majorities, little more than 4 months, enacted one of the most monumental laws in the history of American freedom." Those were the words of Lyndon Johnson as he signed the Voting Rights Act of 1965. Well, we made significant progress since that day, thanks to great men like John Lewis that marched to enact the Voting Rights Act, and the advocates and litigators who battled for decades to enforce it. But there is a grim reality. Insidious voter suppression efforts still continue in America today. These efforts may not seem as obvious as the old school poll taxes and literacy test, but make no mistake, they are aimed at denying the fundamental right to vote, and all too often they are successful. When I was chairman of the Judiciary Subcommittee on the Constitution, Civil Rights, and Human Rights, I decided to travel to the states of Florida and Ohio for public hearings to speak to officials and experts on the ground and determine why those states, through their legislatures, were passing laws, what I considered burdensome laws, such as reducing opportunities for early voting. Why were they making it harder to vote in Ohio and Florida? In both states, I asked witnesses under oath what evidence of widespread voter fraud prompted these laws that made it more difficult for people to vote, limited the time that they could vote. The answer was simple, under oath. What was the evidence of fraud? There was no evidence of fraud. Turned out there were a handful of election fraud cases here and there, rarely prosecuted, and that's it. In contrast to the mere specter of widespread voter fraud, we learned that these voter suppression laws really had consequences. We heard over and over again that restrictive voting laws have a disproportionate impact on whom? Low income, black voters, brown voters, young voters, elderly, vulnerable voting populations. When you make it harder to vote, it's tougher for these people to show up and vote. Someone knew that. After the hearings, we learned more about the real reason behind these laws. According to news reports, Republican consultants and former officials admitted after the 2012 election that Florida law discussed at my hearing was literally designed to suppress the vote, particularly among those leaning toward the Democratic column. A year later, the Supreme Court announced a decision in Shelby County versus Holder. In a 5-4 vote, the divided court struck down the provisions of the Voting Rights Act that required certain jurisdictions to pre-clear any changes in their voting laws with the Department of Justice. The decision effectively gutted the Voting Rights Act of 1965. And in the aftermath, several state legislatures pushed through discriminatory restrictions on voting that previously would have required approval by the Justice Department ahead of time. An example, in North Carolina, the legislature enacted a massive voter suppression bill, including a strict photo ID requirement, early voting cutbacks, and the elimination of same-day registration, out-of-precinct voting, and pre-registration for teenagers who were about to turn 18 before an election. What did a 3-judge federal panel have to say about this North Carolina law? They said, quote, "It targeted African Americans with almost surgical precision," and, quote, "enacted the law with discriminatory intent," close quote. Mr. President, those are unequivocal words. Despite all the press releases to the contrary, the court knew exactly what was going on in North Carolina. They were trying to stop African American voters in that state from being counted. Unfortunately, litigation targeting these voter suppression efforts has faced an increasingly uphill battle as President Trump has packed the federal courts with partisan right-wing judges, including several with appalling records on voting rights. And though the Supreme Court continues to state that the right to vote is both, quote, fundamental and, quote, preservative of other basic civil and political rights, the court has also continued to permit broad assaults on America's access to the ballot box. Let me give you an example. In April, the court first forced thousands of Wisconsin primary voters in April of this year to choose between their health and exercising their right to vote in the middle of a COVID-19 pandemic. The court refused to extend the deadline for returning absentee ballots, despite the public health national emergency we face. A state official recently said in Wisconsin that at least 71 people were infected with COVID-19 after voting in person or working at the polls during that primary election. In June, the Supreme Court turned down a request to reinstate a Texas District Court judge order, which would have ensured that all voters in the state could ask to vote by mail in light of the pandemic. And just last month, the same court refused to lift a stay in Florida that will prevent hundreds of thousands of otherwise eligible Floridians from voting in this month's primary election, simply because they can't pay the fines and fees imposed on them long ago as part of a criminal sentence. What did Justice Sotomayor say in her dissent about this Florida case? Quote, "This court's inaction continues a trend of condoning disfranchisement." Well, it's time for this to end. I'm introducing today a joint resolution. I don't do this lightly. In the time that I've served in Congress, I believe that this is only the second time that I proposed an amendment to this Constitution. I believe, at least personally, I'm humbled by this document. I know it was far from perfect when written. We've learned that over the years with all the amendments and the history that's followed. But I've never thought myself worthy to add words to that document. One other time, on abolishing the Electoral College, I had a bipartisan measure that I offered. But this is the only second time I've done it. This joint resolution would create and enshrine an explicit individual right to vote in the United States Constitution and protect all Americans who seek to exercise this fundamental right. Specifically, the amendment would provide an affirmative right to vote for every American citizen of legal voting age in any public election held in the jurisdiction in which they reside. It would also require that any efforts to limit the fundamental right to vote would be subject to the strictest level of review in the courts. Additionally, it would ensure that states could no longer rely on Section 2 of the 14th Amendment to prevent Americans from voting due to an earlier criminal conviction. Finally, the amendment would provide that Congress has the irrefutable authority to protect the right to vote through legislation. If ratified, this constitutional amendment would protect against nefarious election administration changes that lead to long lines and people beating on doors trying to get in to vote. These long lines have reduced voter turnout on Election Day. How in the world can we be a stronger nation if fewer people participate in the most important part of democracy? It would protect against photo identification requirements that disproportionately harm low-income voters and African Americans and Hispanics. Black lives matter, brown lives matter, American lives matter. And when it comes to vote, this insidious effort to undermine the opportunity for these people to vote has to be called out for what it is. It would also provide a path to end discriminatory criminal disfranchisement laws that are a relic of the Jim Crow era and yet continue to strip millions of citizens of their fundamental right to participate in our democracy. Some may ask why we should pursue this amendment when there are clear and perhaps easier steps that Congress can take right now to protect voting rights under its existing constitutional authority. Let me give you an example. The Senate could quickly pass the John Lewis Voting Rights Act amendment, which the House passed last year. But that would rely on a decision by Senator McConnell to actually let the Senate vote on a measure coming over from the House. There's little hope that that's going to happen. Given the ongoing ruthless assault on voting rights in America, it is clear that additional tools are necessary to push back against widespread voter suppression. I recognize that amending the Constitution is no small matter. I'm well aware that introducing this amendment today isn't going to lead to any immediate change. But I also believe that this moment represents the next step in a movement in America that will ultimately lead to the ratification of this amendment. I'm going to work with my colleagues and constituents to build support. I'm going to ask the opponents why they believe that such a fundamental right, preservative of all other rights in America, in the words of the Supreme Court, should not be affirmatively granted to the American people and literally enshrined in the United States Constitution, the right to vote. I plan to work with grassroots organizations who are fighting for their voting rights to be restored. I'm going to work with Representative Mark Pocan of Wisconsin, who's led this effort in the House. And I plan to work with civil rights leaders, including an old friend named Jesse Jackson, who for years has called for this amendment to be introduced in the Senate. I want to thank Reverend Jackson for his tireless leadership and advocacy. And I'm grateful to have the support of the Rainbow Push Coalition as we introduce this amendment, along with the Advancement Project National Office. Let me thank Senators Warren, Sanders, Merkley, Hirono, Markey, and Van Hollen for co-sponsoring, and I hope others will join us. Mr. President, by accident, I was given a book several years ago entitled White Rage, written by Carol Anderson. Carol Anderson is a professor at Emory University. The book was given to me by my brother-in-law, and I have to tell you, I was skeptical that I'd even read it, let alone like it. Well, I'll have to tell you, I've read it and recommended it over and over again to my colleagues in the Senate, including giving a copy to then Senate Majority Leader Harry Reid. He decided after reading the book it was so good that he invited Carol Anderson, Professor Carol Anderson, to come and speak to our caucus. She's an amazing person and a great historian. And she followed White Rage with this book, One Person, No Vote. In it, she tells the history of voter suppression. It is an eye-opener that after the Civil War and all those deaths to end slavery, after the assassination of Lincoln, and after the effort was made to finally give to blacks in the South a chance to become full-fledged citizens, they ran into Jim Crow laws. She talks about something which I had heard of but knew little about. I'd like to say a word from the book. The question is the efforts made to suppress the black vote in the South. And here's what she writes. This became most apparent in 1890 when the Magnolia State passed the Mississippi Plan, a dizzying array of poll taxes, literacy tests, understanding clauses, newfangled voter registration rules, and good character clauses, all intentionally racially discriminatory, but dressed up in the genteel garb of bringing, quote, integrity to the voting booth. This feigned legal innocence was legislative evil genius. Virginia Representative Carter Glass, like so many others, swooned at the thought of the Mississippi plan to his own state of Virginia, especially after he saw how well it had worked. He rushed to champion a bill in the legislature that would, quote, eliminate the darky as a political factor in less than 5 years, close quote. Glass, whom President Franklin Roosevelt would one day describe as an unreconstructed rebel, planned, quote, not to deprive a single white man of the ballot, but to inevitably cut from the existing electorate 4/5 of the Negro voters, close quote, in Virginia. One delegate asked him, will it not be done by fraud and discrimination? Glass replied, by fraud, no. By discrimination, yes. Discrimination, well, that is precisely what we propose, to discriminate to the very extremity permissible under the federal Constitution, with a view to the elimination of every Negro voter who can be gotten rid of legally without materially impairing the numerical strength of the white electorate. Unapologetic, straight in his remarks. His racism was rampant, and so was it as across this country, so was it found across this country. Black lives matter, America matters, and our democracy matters. Once and for all, the right to vote should be enshrined in our Constitution. People have died for it. It's time for us to work hard to show that we care. Mr. President, I yield the floor.